Okay, welcome everyone. We are going to jump right into the Minegoziibe Anishinabe bylaw. As I mentioned, if you have any questions or comments that you want to make, just please raise your hand and Cynthia will jot them down. Okay, we will begin. Bylaw number 224-1 of Minegoziibe Anishinabe, a bylaw to prohibit illegal drugs. Whereas, pursuant to the inherent authority of families to seek and expect measures of safety in the community, and under the organized powers of Chief and Council, as identified in the Indian Act, the Minegoziibe Anishinabe, formerly the Pine Creek First Nation, Chief and Council is empowered to act on behalf of the individuals and families of the community. And whereas the illegal drug trade on the lands of the Minegoziibe Anishinabe, the reserve, represents a majority disruption and threat to the historical peaceful harmony and well-being of the people resident on the reserve. And whereas the abuse and sale of illegal drugs has been demonstrated to be a major concern to the members of the Minegoziibe Anishinabe and has been a major contributor to violent and untimely death, ill health, family dysfunction, social disorder, destabilizing the peace and harmony of the community, and creating a general sense of a lack of safety and security within the community. And whereas the Chief and Council of the Minegoziibe Anishinabe is desirous to take steps to intervene, disrupt, and limit the abuse and sale of the drugs in the community to promote and protect the peace and harmony of the members within the community. And whereas subsection 85.1 of the Indian Act authorizes council of and to make bylaws, A, prohibiting the sale, barter, supply, or manufacture of intoxicants on the reserve of a band. B, prohibiting any person from being intoxicated on the reserve. C, prohibiting any person from having intoxicants in his/her possession on the reserve lands. And C and D, providing for exceptions to any of the prohibitions established pursuant to paragraph B or C. Whereas a series of community engagement sessions on this proposed bylaw were held on the following dates. So A would be today's date, April 25th, 2024. And as I mentioned earlier, the second date is going to be April 29th, 2024. We will update the community notice that we posted. And the majority of the member attendees of the Minegoziibe Anishinabe and said community engagement sessions endorsed the contents herein as establishing a community bylaw prohibiting the sale of illegal drugs. Now, therefore, it is hereby enacted pursuant to Section 85.1 of the Indian Act and the inherent rights and authority of the Minegoziibe Anishinabe people. 1.0 Title 1.1. This bylaw may be cited as the Minegoziibe Anishinabe Drug Bylaw, the bylaw. Interpretation 2.1. In this bylaw, lands means all those lands defined as a reserve within the meaning of the Indian Act, RSC 1985, C15, and set apart of the use and benefit of the Minegoziibe Anishinabe Pine Creek First Nation. This also includes lands currently held in fee simple by the Minegoziibe Anishinabe or any duly authorized corporate entity owned or controlled by the Minegoziibe Anishinabe. This includes any partnership, joint ventures, and economic development lands purchased for the purpose of advancing the rights and interests of the Minegoziibe Anishinabe. Lands currently in process of transition to reserve through either the additions to reserve, ATR policy, or lands in the treaty land entitlement, TLE process. Lands set aside by the Minegoziibe Anishinabe for commercial designation. Lands controlled by the Minegoziibe Anishinabe under a Crown Head lease or sublease. Illegal drugs means those drugs and substances prohibited or controlled under the Controlled Drugs and Substances Act, SC 1996, C-19. For greater clarity, this specifically includes prescription drugs which are used or in the possession of a person other than the person for whom the drugs were prescribed. This may also include a noxious or toxic substance manufactured, such as boiled, cooked, and/or purposely mixed for the purpose of ingesting or selling as a drug. Council means the Chief and Council of Minegoziibe Anishinabe, Pine Creek First Nation. Person means any person who is present on the land and includes members of Minegoziibe Anishinabe and persons who are not members of the Minegoziibe Anishinabe. Possession means possession within the meaning of subsection 4.3 of the Criminal Code of Canada, RSC 1985, C46. 3.0 Prohibitions. 3.1 No person shall sell, barter, supply, or manufacture an illegal drug on the lands of Minegoziibe Anishinabe. 3.2 No person shall sell, barter, supply, manufacture, or possess cannabis or any derivative of cannabis on the lands of the Minegoziibe Anishinabe without a written authorization by the Council of the Minegoziibe Anishinabe. In addition to a provincial cannabis retail license for the sale of cannabis or a federal license for the processing or manufacture of cannabis. 3.2 The requirement for a provincial or federal license may be subject to change at the discretion of the council. 3.3 No person shall sell, barter, supply, manufacture, for sale, or resell any alcohol or alcohol-related products on the lands of the Minegoziibe Anishinabe. 3.4 No person shall use or be in possession of illegal drugs on the lands of the Minegoziibe Anishinabe. 3.5 No person shall harbor or house an individual who has been removed or banished pursuant to this bylaw. 4.0 Exceptions. 4.1 No person contravenes section 3.0 of this bylaw where illegal drugs are possessed, used, or intended to be used solely for medical purposes upon prescription by a medical doctor in accordance with the Controlled Drugs and Substances Act, SC 1996, C-19. 5.0 Enforcement. 5.1 Every person who fails or refuses to comply with a provision of this bylaw commits an offense. 5.2 The Chief and Council of the Minegoziibe Anishinabe will exercise their authority to give permission and to authorize any First Nation safety officer under the employ of the Minegoziibe Anishinabe, along with a request for assistance of the RCMP, the right to search any home or person or persons suspected or reported of providing supplying, or selling illegal drugs or intoxicants on the lands of the Minegoziibe Anishinabe. 5.3. Every person, after having been searched under Section 5.2 of this bylaw and having been found to be in breach of the provisions of this bylaw, shall be subject to seizure of any illegal drugs on their person or in or on the premises. 5.4. Every person, after having been searched under Section 5.2 of this bylaw and having been found to be in breach of the provisions of this bylaw, shall be subject to the full extent of criminal charges brought by the RCMP and under the provisions of the Criminal Code of Canada. Penalty. 6.1. Every person who commits an offense under this bylaw is liable to criminal sanction brought by the Criminal Code of Canada. 6.2. In addition to criminal sanction, every person who commits a breach of this bylaw may also be subject to the following penalties. A. Termination of employment with the Minegoziibe Anishinabe. B. Termination or denial of assistance of any kind, including but not limited to social assistance, economic or education support. C. Termination of access to banned hardship donations, sponsorship, or any other banned sponsored forms of assistance for a specified period of time, not less than 1 year and up to and including 5 years. D. Denial of housing on the lands of Minegoziibe Anishinabe. E. Removal of names from the housing application waitlist for a period of up to 5 years. F. Eviction from housing on the lands of the Minegoziibe Anishinabe. This includes any person or persons residing in abandoned housing pursuant to the terms of a tenancy agreement issued by the Minegoziibe Anishinabe Housing Authority. G. Publication of the names of the offenders in public places in the community. H. Refusal by the Minegoziibe Anishinabe and its affiliated or related companies and their agencies to do business with such persons. I. Removal or banishment from the land of the Minegoziibe Anishinabe for a term set by Chief and Council or a duly authorized agent of the Chief and Council operating under a duly authorized mandate to address removal or banishment. J. A monetary penalty as set by Chief and Council or a duly authorized agent of the Chief and Council operating under a duly authorized mandate to address a monetary penalty assessments. K. A restitution order as set by Chief and Council or by a duly authorized agent of the Chief and Council operating under a duly authorized mandate to address restitution. Oh, sorry, I didn't see you, Kate. We have a question. So the bylaw is not enforceable yet. First, it's got to be presented to the community at two meetings. Once it's presented to the community at 2 sessions, then it goes back to Chief and Council. Chief and Council will then make a motion to accept the bylaw. And then from there... Correct. No.
Because I have a question about my nephew being thrown out of his house.
Okay, so yeah, but that we have a tenancy agreement, And in our tenancy agreement, that's where it states
The
that.
house meeting?
Yeah,
Okay.
okay. Was I on 6.3? 6.3? Okay. 6.3. Thank you for your question. Every person who is subject to any penalty under this bylaw will be notified of the specific penalty in writing. The penalty notice. The penalty notice shall contain A, the date of the offense, B, the location on the lands of the Minegoziibe Anishinabe where the offense was committed, C, the name of the person who committed the offense, D, the penalty imposed on the person, including any charges raised by the RCMP in right of the Crown, E, the date for which a monetary penalty under 6.2J is due and payable to the Minegoziibe Anishinabe, F, the date for which a penalty under 6.2 expires, if there is an expiry date, and G, the form and requirement for an appeal of a decision or penalty pursuant to the procedure set out in 9.0. Seven point zero, ban council resolutions. 7.1, the council may make ban council resolutions respecting any matters that the council considers necessary or advisable to meet or further the objectives of this bylaw. 8.0, drug testing. 8.1, to further the objectives of this bylaw will run concurrent to existing drug testing policies used throughout the administration and operations of the government offices of Minegoziibe Anishinabe. 9.0, procedure. 9.1, all penalties provided for under section 6.2 shall be imposed pursuant to any rules, guidelines, contracts, or other procedures that govern the corresponding service or relationship. 9.2. In applying section 9.1 to corresponding procedural provisions, attention should be paid to the severity of the offense, including whether it falls under section 3.1 to 3.5 of this bylaw. 9.3, right to appeal a decision of chief and council or its authorized agent. Any person who has been removed or banished from the lands of the Minegoziibe Anishinabe pursuant to section 6.2I may appeal that decision to chief and council or an appeal committee appointed by chief and council for this purpose. A, any person intending to appeal a removal from housing or banishment must notify chief and council or the duly authorized agent of chief and council, such as an appeal committee, in writing no more than 5 business days from the notice of eviction and no more than 10 days from a notice of banishment. Notice of appeal. B, the notice of appeal shall be in the written form prescribed and authorized by chief and council or the duly authorized agent of the chief and council, such as an appeal committee. C, the notice of appeal or requirements will be expressly written and identified on any penalty notice. D, within 10 days of the notice of appeal being provided to chief and council or its duly authorized agent to address such matters, such as the appeal committee, a hearing must be held at which time the evicted or banished person shall have the opportunity to bring forward material evidence and support to plead their reasons for reconsideration. In doing so, the person shall have the opportunity to bring material evidence, information, or testimony that is relevant to the decision that is being appealed. This hearing will be limited to 90 minutes unless otherwise approved by Chief and Counsel or its duly authorized agent, such as the Appeal Committee. E. Any appeal hearing is closed to the public unless otherwise provided for by Chief and Counsel or at the discretion of a duly authorized agent of Chief and Counsel, such as the Appeal Committee. F. In making a decision on the appeal, the Chief and Counsel or a duly authorized agent of Chief and Counsel, such as the Appeal Committee, shall take into account the following factors. A. The nature and severity of the offense, including whether it is an offense under this bylaw and the Criminal Code of Canada. B. Any attempts made by the person to attend rehabilitation at making reparations or otherwise attempting to repair any harm done already or preventing future harm. C. The connection of the individual to the community and its members, including whether the individual has any dependents for whom their removal from the community would be detrimental to the well-being, mental and physical health of the dependent. D. The extent to which the banishment in the specific case contributes to the objective of this type of sanction, specifically whether banishment of the individual would be in the best interests of the safety and protection of the community. E. Any other consideration that the Chief and Counsel or its duly authorized agent to deal with the matter, such as the Appeal Committee, deems relevant to the decision. G. Chief and Counsel or its duly authorized agent for this purpose, i.e. Appeal Committee, shall communicate their decision on the appeal within 5 business days of the hearing date. H. Decisions made by Chief and Counsel or its duly authorized agent for such purposes, i.e. Appeal Committee, are final. 9.4. Banishment pursuant to Section 6.2I of this bylaw shall take effect at the discretion of the Chief and Counsel or its duly authorized agent designated to address such matters. 8. In cases of extreme harm or victimization, banishment can be effected immediately by way of a special band council resolution identifying the reasons for immediate banishment and the term of said banishment. B. In the case of pending criminal charges, a criminal charge banishment can occur not less than 10 days or the last calendar day of the month, whichever is longer. For example, if finding of a banishment is found on the 15th of the month, banishment could take effect on the 25th of the month. In the case of banishment becoming effective on a penalty notice, within 10 days of the end of the month, the person shall have the full 10 days to remove themselves from the lands of the Minegoziibe Anishinabe. C. In the case of appeal notice being received within the prescribed time frame identified in Section 9.3A, an appeal hearing is granted, banishment or eviction would take effect after the hearing date and within the prescribed time frame identified in Section 9.3G. 9.5. Chief and Counsel or their duly authorized agents delegated responsibility for this purpose, i.e. Appeal Committee, may use their discretion in providing conditions on individuals who have been banished pursuant to section 6.2I, including allowing the banished individual to temporarily re-enter the lands in specified circumstances, such as funerals or any other circumstances they see fit. Any conditions must be made in writing by a quorum of chief and council. 10.0, conflict of interest. 10.1, any member of chief and council is in a conflict of interest if the person examined under the provisions of this bylaw is a direct family relative of the decision-making chief and/or member of council, or any duly authorized agent to the chief and council, such as the appeal committee. For greater clarity, a direct family relative is A, a child of the member of chief and council, B, a brother or sister of a member of chief and council, C, a parent, mother or father of a member of chief and council, D, a husband or wife of a member of chief and council, E, a common law husband or wife of a member of chief and council. 10.2. In instances where a direct family relative is implicated in the possible breach of a provision of this bylaw, that member of chief and council or its duly authorized agent, i.e. appeal committee, that member of the chief and council will expressly identify conflict of interest and recuse themselves from any participation in any of the decision-making processes or processes identified by this bylaw. 10.3. In a situation where there is a significant family connection by way of custom or traditional adoption, a member of chief and council or council may recuse themselves from a decision-making process if their participation may remove the impartiality of their decision-making ability, or if there's a reasonable apprehension of bias. 10.4. In a situation where a member of chief and council have not recused themselves of participating in a decision-making process under this bylaw, and there is a reasonable apprehension of bias raised by an individual or their advocate, the issue of conflict of interest can be raised as part of an appeal hearing. 11.0 miscellaneous. 11.1 should a court of jurisdiction determine that a provision of this bylaw is invalid for any reason, the provision shall be severed from the bylaw, and the validity of the rest of the bylaw shall not be affected. 11.2 this bylaw comes into force on the day of enactment by way of band council resolution and subject to the terms of affecting bylaws under the Indian Act. 11.3 nothing in this bylaw shall be read or understood to abrogate or derogate from the Aboriginal and/or treaty rights pursuant to Section 3.5 of Canada's Constitution. Passed at a duly convened meeting of the Minegoziibe Anishinabe Council and subject to community review from time to time on this 25th day of April in the year 2024. And then our current leadership, Chief Derek Neepanat, Councillor Cindy McKay, Councillor Dawn Chartrand, Councillor Angela McKay, Councillor Harley Chartrand, and it'll be witnessed by someone. And that is the Minegoziibe Anishinabe legal drug bylaw. Are there any questions? Comments? Rachel?
I have a question and then we'll, you talk to your parents. for the office, health office, and the, was everybody, drug tested?
We,
I know it was not a few years ago, but that, you hear things, you see things.
Yeah.
People were coming to work on time, a few people were drug tested, but not everybody was drug tested, that's a few years ago.
yeah.
So I don't know, is everybody drug tested?
So the question is, regarding the employees of the being drug tested. And the answer is yes, we are still conducting random drug testing. Yeah. Yeah. Yeah, we have a question.
How often is your random drug testing?
It's once a month.
How many do you test?
One question was how often do we drug test, and we drug test once a month, and how many do we drug test? We can drug test up to 6. Randomly, no. They don't know they're gonna be tested until like, an hour or so before.
What usually happens if they're doing drugs?
If they are doing drugs, we want to work with them, right? We don't want, someone to have to, stay in that state. So we will provide options of rehab or getting some type of help. But of course, it has to be, the person has to want to take those steps. Failure to take those steps would then result in termination. Loretta?
Who does the drug testing?
We have our community doctor, Dr. Menard comes in. Yeah.
That's what I wanted to confirm.
So when they are in, for example, if they're getting help, are they still getting their wages paid and everything? Because they're trying to help themselves.
Yes, yeah.
So there's some that chief and council will be supporting the individual.
Well, they will still be, like, the question is if someone tested positive, depending on the severity, right? Like if the person is, like for example, transporting children and that type of thing, they may be removed from their position for safety reasons. But typically, the employee would have the opportunity to continue working under like the provisions like of rehab and help.
So if, say I was tested positive and I agreed to go to rehab, and I'm there for how long? Are they there for a month?
I think it would be dependent on, I think every individual, it's due to their assessment.
Okay, see if I was working at the band off and I was in rehab for a month, what would happen? How would they help me? Would they give me my regular paycheck? Or what would happen?
You would still be working, like if you did take a program to help yourself, you would be able to take that program and still work at the same time as long as you were following the guidelines, I guess, of the program.
Because isn't there a place where they send these people that are, whatever, all, that are,
Oh, like a detox center? Yeah, there's places there's detox centers, but.
so what would happen if I was working, I was sent to a detox center and I ended up being there for a month?
Okay, so you're saying if you had to like leave the community,
Yeah.
then we would, like, we would work with you and you would have probably be on a leave. Yeah. Depending on the situation, leave without pay might be one of the options. Or you would access your benefits because, your insurance, you might be able to access, an income through there.
On the radio this morning, I heard that because like people can buy um, products from like places, drugs. I heard that now, like say if I wanted to grow, like I can get a permit and I can grow 4 plants in my home. How is this gonna supersede that?
It does mention that in here, that with the approval, you would just have to receive, permission from chief and council. Yeah. And for the drug testing, to clarify, like cannabis is legal now, and so we don't test for cannabis. We treat it as alcohol, right? Like an employee is not gonna come to work under the influence of alcohol, so an employee won't come to work under the influence of cannabis.
But it's custody of a mom, right? But this is custody of a mom. That's how you could have that. And they're all-
Like if they're growing their own cannabis?
Oh, okay, why can they have it?
Oh, I am not even. Yeah, for medicinal purposes. Yeah, I don't even know how much you could have on in your person. Yeah, it's a good question. So yeah, if there's no more questions, we are going to turn off the live, and then we will have another session on Monday, April 29th at 5 p.m. again. Thank you all for coming.